Morning, Lord.
Yes, yes.
We have Dr. Lawellman, sir, Assistant Professor in Law, GLC, Calicut as person. Welcome, sir. And the section will be on trademark law. Handing over to Lawellman, sir.
May I know who is this speaking?
I'm Roshan Jibin.
Your name is Roshan.
Yes, sir. Roshan Jibin.
Okay, okay. But yeah, yeah, yeah. It could be. Yeah, that's fine. Thank you, Miss Roshan, for just introducing. It's not necessary these days because we've been doing this exercise for quite a long time now. Now, there is one correction I would like to make, a kind of disclaimer. The area we are going to discuss today is not trademark, though the poster says so, because we have not completed patent yet. We may have to have a few more days to complete patent, then we'll definitely do trademark also. So we'll be discussing patents today, which we started in the last class, last interaction, what we call it as. So, Ms. Roshan, may I go to the,
Yes, sir.
yeah. Now, we were on the essentials of an invention in the last class. The importance of essentials of an invention when we discuss patent is this: patents are granted for inventions. Inventions which are patentable will have to comply with certain qualifications, and those qualifications are called essentials of an invention, patentable invention. And as you might know already, there are three essential qualifications a patentable invention should comply with. The first one is novelty, second one is inventive step, and third one is capable of industrial application. Novelty means it should be new. Inventive step means there should be technological advancement. And third one is that novelty and technological advancement should be a positive one, in the sense that should be a positive utility, or we can call it otherwise as utility. So these are the essentials of an invention. Now, moving on with this, we discussed what you call the requirement of novelty, which says that it should not be prior published, should not be prior used, or it should not be prior, known anywhere in the world. If it is part of prior knowledge, if it is prior published, if it is prior used anywhere in the world, it would mean that it is not new. That is understandable. And please note, anywhere in the world, that's a requirement. Or in a few more formal technical words, technical sense, it means that what a person is claiming claiming a patent should not be part of state of art. State of art is an important consideration there. State of art would mean the present state of affairs of the technological development in that particular area. If it is a pharmaceutical related invention, what's the present state of affairs as far as that particular area of pharmaceutical is concerned? And the question is whether it has gone forward from that. So if it is already known, or if it is already part of state of art, then it is not novel, it's not patent. That's the situation. And for which we will search throughout the world, or the process, the requirement is that. Now, this has already been considered, and we knew that It could be publication in anywhere in India or anywhere else. It could be in magazines, technical journals, books, newspapers, oral description in a seminar or a conference. All these are there, part of it. So we call this as prior art or state of art. If it is part of state of art, then there is no novelty, and then the invention gets disqualified. Otherwise, it can go forward with claim. That's how it should be understood. Now, here an important consideration, obviously, that should arise is, what do you mean by prior publication? And what's the kind of publication that is required? For which I think I gave an example, which the participants would definitely remember. I guess the example that Times of India or Times has come out with a 3-column news or a 2-column news about an automated teller machine. Think for a moment, there is no ATM now. And Times now, or Times has come out with, Times newspaper has come out with a 3-column news which says that there is such and such machine and that will do such and such function. That's all. If that if that information has come out in the open, if it is published in the newspaper, will that defeat the requirement of novelty? Will that defeat the requirement of novelty? That's a question. So if there is prior publication, then it will defeat a novelty and there is no patent for that. That's how we need to understand this. And how much of information, what kind of information should come out? What kind of publication should be there? What is the sufficient or adequate publication so as to defeat the requirement of novelty? So the example I gave, a 3-column or 2-column news in a newspaper, will that be sufficient to defeat the requirement of novelty? That's a question. And for which we have a case here. The case is Lalubai Chakubai Jariwala versus Chimanlal Chunilal and Company, in which the court has made an observation. It's an old case, but the observation is still handy and still holds good. With regard to sufficiency of knowledge, says that it must give sufficient information to a workman skilled in the particular art. I'll go once again. It must give sufficient information. The information should be so much that a workman would mean a person who is abreast of the present technological state of affairs, who knows all the technology presently. And if it is shown to him, what would he say? That's a kind of a test that is laid down by the court. So it must give sufficient information to a workman skilled in the particular art or craft in order to enable him, this person. It's not an ordinary person, a lay person who doesn't know anything about this particular area. If it is pharmaceutical, a person who doesn't know. For example, if myself, I'm not, I do not know the technology in pharmaceutical industry. I'm not an example for this. If there is a pharmacist or a person who has got sufficient knowledge about this present state of affairs in the pharmaceutical industry, and if this particular publication is shown to him, and if he says, yeah, this information, this 3-column news is sufficient for me to make the product of that invention or carry out that invention, then that is a publication. So the publication requirement, so as to defeat the requirement of novelty, is this: it should be sufficient for a person expert in that area to enable him to carry out the invention. Am I making sense, Ms. Nitu? Am I making sense? This is an important thing. In fact, that's the reason why I thought I'll just take some information. Is that clear, everyone? Advocate Reshma Obbi, is that clear?
Yes, sir, it is clear. Please carry on.
Okay. Yeah.
Yes, sir.
Thank you. No, so that's a requirement, and there is another thing which we should be keeping in mind. That is, if some information is in fact available in the public domain, but nobody has in fact read it, in fact no, no, mm, no, taken in, or rather read and understood. A good example could be something which is published in the Gazette. Gazette publication is considered to be a kind of most proper publication, a proper notice. But many times, as we know, that that rose book, pink book, we never read. But the publication there will be considered to be a publication. So what's a requirement under patent law to constitute a sufficient publication so as to constitute an anticipation? We say that anticipation. If the invention presently brought before the patent office is already anticipated because of the publication, already expected or already known or already used, already published, then there is no patent. I'm repeating it, but it is important. So we are looking for such an anticipation. The patent office will look for such an anticipation. We call it as anticipated. So here the situation is this. The case is also the same. Situation is this: the information is available in a particular book, or it is available in Gazette, or it is available somewhere, but nobody has touched it. Will it defeat the existing claim for patent by a new inventor? The information was already published earlier, but nobody has read it. It is available in a public library, in a particular file, in a particular book, but that particular book has never been lent or borrowed by anyone, and nobody has read that book. That is paka. It could be seen in many of our libraries, I guess. So if the position is that, will that constitute constructive notice so as to defeat so as to defeat what you call the novelty requirement? That's a question. As an answer to this, what the court has said is, it may not be necessary that members of the public have actually read it. The most important sentence I would like to emphasize on, I would like you to have a look at, is it is enough if the publication is accessible to the public without much trouble. For example, if the document is to be found in the library of the government, patent office in Calcutta or anywhere else, it's an old case and it is an old observation, but it's still it would still hold good. Or in the shelves of the public library in any place in India or elsewhere. So if had that been available in the public, though the public has actually accessed or not is a question immaterial. The requirement is, if it is available in public, that will act as a constructive notice, as a constructive publication, and that will defeat the requirement of novelty. That will be that will be something which is considered to be used, considered to be known, and so there won't be any novelty, and that will defeat the patentability of that particular invention. That's the requirement. Now that's I think that's sufficient discussion on the first requirement of novelty. How that is in fact verified practically will be discussed later on when we discuss the procedure of patenting, which we'll do in a brief manner, perhaps after 1 or 2 classes. So now we are moving to the second requirement of a patent. Sir, what if the publication is accessible public? And yeah, I couldn't get it. Let me see. Call messages. Karun Sanjaya. Yeah, sir, what if the publication is accessible to the public and it is not read by anyone, but it does not contain sufficient information that would enable a person skilled in the art to come up with the invention? Yeah, I think both these requirements, both the discussions, both the sufficiency of information, and anyway, it's good that there is a question my response to that the question is this: both these conditions should be complied. It should be available in the sense, even though it is not actually accessed, it should be available to the public, and the information available to the public should be sufficient information, so as to enable a person skilled in the art to operationalize the invention or technology. Only if both these requirements are complied with, then only there will be a problem for novelty. Otherwise, there is no problem. Would that be fine, Mr. Karun? Mr.
Yes, sir. Yes, sir. Thank you.
Yeah. Miss or Miss? Mr.
Mr. Sir, Mr.
Okay. I'm sorry. Sorry, sir. Okay. Now we'll move to inventive step. That's the second requirement. Would you mind, Mr. Karun, or would you mind reading this out, please? I hope you don't mind, right?
Sure, sir. Sure, sir.
Thank you, sir.
So, inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art.
Yes. Yeah. The person skilled in the art is the hero of the drama of patent. Reasonable man is the hero of the drama of tort. In tort, for negligence and very many other specific torts, the test laid down by the court is that had a reasonable man or a woman, had that person would have done this. That's the question. Likewise, most of the things, most of the important concepts are explained out or practically considered by the patent office and the courts from the point of view of the person who is skilled in the art. Is the person who has got knowledge about the present state of affairs, the present state of art, the prior art, the existing art in that particular area. So most of the things are considered. The violations are considered from the point of view of the person skilled in the art. He is the most important person. She is the most important person. So is the case with inventive step also. We had that person coming in to understand, make us understand the concept of novelty. So is the case with inventive step as well. Now let us distinguish between novelty and inventive step first of all, and then we will understand what it is. Thank you, Mr. Karun, for reading that out. Now, novelty would mean it is new. But everything that is new will not be considered as patentable. Because patent is granted not only for novelty, not only for something new, but there should be a contribution of technical advancement by the person who is claiming patent over it. Now, the usual example I give whenever I speak about this particular thing is the example of a thing called bucket torch. Miss Jisha, have you come across bucket torch? Or Miss Roshan or whoever? Have you come across bucket torch? I'm sure that none of you must have come across that. Bucket torch is nothing but a torch attached to a bucket. That's all. So if you have not come across it, then definitely it is not. It's new. It's new. Now, being new by itself, will not be sufficient. And that requires a cumulative, there is another cumulative requirement. In addition to novelty, there is a requirement of inventive step. The inventor, the person who is claiming a patent, should have gone a step forward. That's the way I understand it. That's the way I would request you to understand that. The person who is claiming patent over the invention should have taken the invention in a step forward in the direction of technology. He should have gone a technology step forward. Now, if you read the definition, that's what it says, and it's the test laid down to test this. Test laid down to test this is it should not be obvious to the person skilled in the art. It should not be foreseeable for the person who is skilled in the art. The person skilled in the art is a person who is abreast of the present state of affairs of that particular area of technology. Just think like this. If you are showing this particular patent application to a person skilled in the art, an ordinary person skilled in the art in that area, if he says, this is obvious to me, I would have done it. I could have foreseen it. There is nothing great in it. If the person gives such a response, it means that there is no considerable technological advancement between the present existing thing and the thing that is being claimed patent for. On the contrary, if you show this particular invention to the person, he says, yeah, this is, and if you ask, is this something which you would have made? No, I could not have made this. Considering the present technology, this is, no, there is substantial difference between the present technology and what the person is claiming it. So if it is not obvious to the person skilled in the art, if it is not foreseeable to a person skilled in the art, then definitely that has got inventive step. Only if it has gone a step forward in the direction of invention, we call it as there is inventive step. And if there is only inventive, only if there is inventive step, we will be granting patent to the person concerned and for the invention concerned. To understand this, we may have to consider a case from the Supreme Court, the Honorable Supreme Court of India itself. We have got a very few cases from Supreme Court of India in the area of intellectual property generally, and in the area of patent specifically. Here, the case we are going to consider involves a technology of manufacturing of utensils. What you have, I invite your attention to the screen, the pictures on the screen, and it's like this. You have a raw piece of steel, black in color, on the left side. This is this is what I could gather when I typed raw steel in Google. What do you call Google images. And the plate we use to eat, not the plate in the sense we don't eat plate, or the utensil which we use for the purpose of containing our food, would almost look like this, what you have on the right side. So there is a manufacturing process involved in this. I gave this as an introduction to that particular case because if we have this idea in mind, it's very easy for us to understand. The case is Bishwanath Prasad Radheshyam versus Hindustan Metal Industries. That's the case. The facts are like this. A person is claiming invention with regard to the method of manufacturing utensils. So the thing involved is a method to turn scrap and polish them on some sort of headstock without a tailstock. To workers as utensils used to fly off from the headstock. This much words may not make much sense to this. What happened? The idea is this. In order to transform the raw steel to a finished product, there is a process. And this is done using a lot of force and under a high temperature. So that is the process that is described as the first sentence there, to turn scrap and polish them on some sort of headstock without a tailstock. So there is a particular machine used in this. There's a process involved in this, and there is a headstock in that, and that will be used for the purpose of turning this and also polishing this, and this is done under No, it's a lot of forces involved in this, and it is done under a very high temperature. So usually there was a risk. Then come to the last requirement there. There is a high risk to workers as utensils used to fly off from the headstock. Headstock is the thing with which the machine holds that particular, the hard material called steel, iron with carbon. So when you make this process happen as a workman, there used to be a lot of risk, because this is a very hard thing, and it's put to a lot of pressure, and then it's done under very high temperature. All these are there. So, and from this grip called a headstock, it used to fly off. So that used to be a risky affair as far as the workman was concerned. Now, a person comes out with a method of manufacturing, an improved device. Is claiming a product patent for the device, and the method used and better method of manufacturing utensils. Is coming out with a better device, which has a better method of making utensils. Here, the major problem that existed in the past was this particular thing used to fly off, and that used to be risky for the workman, and many a times it used to be problematic for the workman. Now the new device and the new method for which the person is claiming patent is a better device and a better process, he claims or she claims. They say that this has the advantage that the material will not fly off during the process of manufacturing. We have a new thing added to it. So by adding this new thing to the device, to the already existing device, the device is a better device, and the method is a better method in the sense that there is less risk. So as this is a better device and a better method, I should be given patent for that. That's the tone and tenor of the argument. Okay. But what happens is, on evidence was produced, and there was a dispute. Somebody disputed this. His dispute was that this is something which is already existing. The person says that though this particular technology is used in this area of making utensils for the first time, this is already known in the industry. This method is already known in this industry, but though it is already known in the industry, this is not used in this particular area. That is the counter argument. So what the person has done is, the person who is claiming patent has brought in an already existing technology to a particular area to which it was not introduced. So in this particular area that was not existing, but this idea and this method was existing in certain other areas. So this is how it happens. Now the court had to decide whether this is sufficient, sufficient inventive step, sufficient quantum of technological advancement so as to give a patent. What the person has done is, he has just borrowed and brought in a technology which is already existing in another area. But please note that bringing in technology from another area will not be a very easy method. In certain cases, even if the technology is already known, making use of that or using it in this particular area itself will be a challenging task. Because in this area, there may be a particular problem which will be a big challenge for bringing in that technology here and making use of it in this particular area. That could be a challenging task. There could be situations like this also. Anyway, with this background, let us consider further the case further. On evidence, it was found that similar method was prevalent in the industry. And what has happened is, there was an improvement. However, there was an improvement that certain bracket or angle was additionally used in the device, which gave some advantage. Though the method which he has brought into this particular area is known here, he has made certain additions, certain, what you can call as a workshop improvement. The quantum of improvement of himself is not very substantial. So if you read the case further, the whole thing will boil down to this particular point. Whether the improvement of this, adding a bracket and an angle to an already existing technology and bringing the technology to this particular area, whether this non-substantial technological advancement is sufficient to constitute the quantum of technological advancement so as to constitute inventive step. Put it in different words. What should be the quantum of technical advancement so as to constitute inventive step for the purpose of patent? So here what you can see is, if you consider this matter in the light of the case, the present case in hand, the technology which he has brought into this particular thing is already known. He has just borrowed and brought it here. He has got some addition to that, but that's not a great addition. It's an insubstantial addition. You can just call it as, at the most, you can call it as a workshop improvement. Ultimately, what the code has said is, there is no inventive step. There is no sufficient inventive step. There is no sufficient technological advancement. That's what the code has said. To go further, inadequate quantum of technical advancement. The technical advancement, if at all it is there, which the person claims, is not an adequate quantum, adequate measure of technological advancement so as to constitute inventive step. So there is a minimum requirement of technical advancement so as to constitute inventive step. There should be some substantial technical advancement. Then only your invention or invention will be considered as a patentable invention. So there is a measure, there is a quantum for that, and that would depend, and that will have to be considered in the light of each and every case, at least as an indicator from the point of view of this case. In the light of the present case, what we may have to understand is this: the quantum of advancement involved in this case of some insubstantial addition here and there will not constitute inventive step so as to constitute non-obviousness or inventive step under patent law. So the point I would like to add here is, which may not be obvious to you, is, though the thing is novel, though this particular device is novel, it does not involve enough inventive step. So for lack of inventive step, though there was novelty, this particular invention will disqualify as a patentable invention. Here comes the importance of the requirement of inventive step. Or rather, inventive step is the heart and the most important requirement of patentable invention to me. Because this is the area, this is the requirement which really says that the patent will be granted only if there is a technical advancement, only if there is a technical addition from your side, from the side of the person who claims patent, then only a patent will be granted. Or rather, the very purpose of the patent law will be served only if this requirement is insisted upon. So should be more than a mere workshop improvement. That is one of the major observations of the court, the Honorable Supreme Court of India in this particular case, and this is really indicative. Improvement should not be obvious to a person skilled in the art, and it should not be a mere workshop improvement. It should be a substantial technical advancement. It should not be obvious to a person in this particular area. As far as this invention or this so-called invention is concerned, this particular case and the matters involved in this case is concerned, if you show this to an expert in this area, he would say that this is already existing in the industry, though this is not used in this particular area. So it is known to him. It is obvious to him. He can work this. He can work this invention. So this improvement is obvious to a person. It's foreseeable to him. If it is shown to him, he would say, "Oh, this is something already existing." Yeah, there is some sort of additions here and there. Workshop improvement. It's not substantial. If this is the kind of response a person skilled in the art gives, then it is not patent, because it it does not involve enough inventive stuff. Is that all right? Is that
Sir, I would like to ask a clarification from you regarding this.
definitely.
Yes. Sir, this Radhesham case, it was decided in 1980s. At that point of time, we did not have a definition for inventive step in our Patent Act.
Right.
It was included in the year 2002 and later amended in the year 2005. So can you please go to the slide which shows the definition?
Yeah.
Yes, sir. Here it is mentioned that it means a feature of invention that involves technical advance or having economic significance.
Okay.
So, technical advance is not mandatory as per the latest amendment. A mere economic significance that would not be obvious to the person skilled in the act will also constitute an inventive step.
Yeah. So if you have a technical advancement, if you have economic significance, which is not obvious to this person skilled in the art.
Yes.
Even if it is, in fact, this is not a good definition. This is how a definition should be to me.
Yes,
If I go to the drafting of legislature and also interpretation, this is not a good definition. This is a non-coherent definition, I would say. Because ultimately they could have made it very simple. They have simply made it confusing. See, even if it is economic significance, which I also got trapped when I read it earlier, years back. I also got trapped with this economic significance. But ultimately it says it should not be obvious to a person skilled in the art, which means that it should be technically, there should be a technical advancement.
But sir, won't you think that if Radhesham case was coming up after this invention, I mean, after this definition came up, would the court have a different opinion? Because would the court say that there was an economic significance in that whatever parts which was added?
Yeah, court would not have said that. Had I been the judge, I would not have given an order in favor. I would have gone I would have given the same kind of judgment, because I would definitely go to the question of whether this is obvious to the person skilled in the art. Then the answer, very, very properly, very genuinely, as a judge, what I would get is, this is something which is obvious to the person because it's already existing in the industry. And if at all there is an improvement, that is just an addition of a bracket, which is not a sufficient quantum of inventive step. That's my opinion too. What I'm saying is my opinion, but I genuinely believe. Even now, the Radhesham decision would have been a good decision. In the sense, a proper law.
Okay, thank you, sir.
It's good that you're going deep into it, and that economic significance actually is a symbol and unnecessary confusion brought in by the legislators. I don't know why they brought in. This is not a good drafting and good definition. Okay. I think you also you also share the same opinion because of this sequence. Go to the last part.
Yes, sir. I do.
I emphasize that it is not only boldening but also underlining that, because this will apply for both technical advancement and economic significance. They could have said and there, then the confusion would have been much less. Here it has brought in unnecessary confusion.
Yes, sir.
Anyway, it's good that you have really brought in this particular point. Thank you for that. Thank you for the lively discussion.
Thank you to you, sir, for contributing more.
Thank you so much. So I think the point is made, right? There are very many cases on this. I thought of just discussing one case, which will put the ideas across.
Yes.
Okay, thank you. I like to be questioned because I will also be made to think more, and sometimes I may get something more. Definitely, if you have something, definitely put across. No formalities. Thank you.
Sure, sir, sure.
Okay. Uh, now we have got some cases also. This is a case from the area of pharmaceutical, Catalan pharmaceutical case also. Here also ultimately the point you would get, the principle we will reach will be almost the same. So I may not discuss that case because it's a matter of conveying and isolating a bacterium. Of course, in a different area, but the principle we may deduce would be the same. So we may not go to that particular case. We'll move on. Now, there are certain steps usually devised and usually used or usually followed by the courts for the purpose of determining inventive step. We'll just read that out. This will be obvious to us as we have gone through this particular case. The process involved for the purpose of determining inventive step, whether there is in fact inventive step or not. That's the question court is considering. For the purpose of considering that question, the court would go through these processes. First of all, determining the scope and content of the prior art. It will ask the question, what's the existing technology? Because what the court is made to look at is, there is a technology which claims that this is better than the present invention for which a person is claiming a patent. And what he says in a way is, I've got a technology which is a better technology than existing technology. So what's the prior art? What's the existing technology? That will have to be gone into by the court. So this is something like a common sense. Court will have to go to the present technology. Prior art, we call it as technically in patent law sense. And then define the technical problem to be solved as the object of the invention. So what was the problem faced by the persons in the present state of affairs? The present technology was lacking in certain things. So what was the problem, technical problem? The prior art or the present art, which present has not complied with. Then the third step, assessing the technical result or effect and economic value achieved by the claimed invention. Now we have a present invention. And what's the economic significance? Of course, the matter of economic significance is also brought in. And very deliberately, I have put this and. That and was not just a simple and there. That was a deliberate and from my side. Assessing the technical result and economic value, both. But both are not required. Even if there is no economic value, just because of the technical advancement, even if it does not have much of an economic significance, it could be patentable. That's my point of view, because that's what the definition indicates. So then the third step the court would go to is assessing technical result or effect and economic value achieved by the claimed invention. Whether the claimed invention has gone a step forward. We reach the same place where we started off. Then assessing the differences. This is an important step. Actually, this is this step which will give us a result, because you are fully aware of the present technology. You are fully aware of the technology in which patent has been claimed. Then you go for a comparison. So you keep these two things side by side. It may not be the way in which it has been done, but usually let's think that the present technology is not, prior art is not, and there is the new invention. Specification is here. And you go for a comparison between these two, assessing the differences between the relevant prior art and the claimed invention. And there is an inverse proportionality. If there are more and more differences, then more and more chance for what you call getting a patent. Determination of non-obviousness, which means whether the person of ordinary skill could bridge the differences between the relevant prior art and the claim at issue. Whether a person who is an ordinary workman in this area would have been able to bridge the differences between the prior art, the relevant prior art, and the claim, the present invention, the so-called advancement. Had he been in a position to bridge this gap himself, an already existing, a person who is an expert in the already existing technology, had he been able to bridge this gap, then there is no much difference. There is no inventive step involved. If the thing is otherwise, if the person is not in a position to bridge the gap, which means that gap is a large gap, differences are more. If there are differences are more, then there is technological advancement, inventive step is involved, more and more chance of getting a patent. Would that be all right?
Yes, sir.
Yeah. Now we are moving to, we discussed two, and we are moving to the third, the concept of capable of industrial application. Capable of industrial. I may not be spending so much of time in this particular area. This is otherwise known as utility. You might already know that. I may be stating the obvious. Capable of industrial application. This is otherwise known as utility requirement. It's not sufficient that the invention for which you claim a patent is novel. It's not sufficient that the invention for which you claim a patent is additionally having technological advancement or inventive step. There is a third requirement also. The third requirement is that there should be positive utility for this. There is positive utility for this. I'm repeating it because I want to underline that. The definition goes like this: capable of industrial application or utility would mean, in relation to an invention, means that invention is capable of being made or used in an industry. Can you have an industry for atom bombs? That is not allowed, because that cannot be allowed. No, I'm just trying to put some ideas across. Utility or capable of industrial application usually means a positive utility. If the person is coming out with a technology, a new device, which is so much useful for breaking the lock open in 30 seconds without any sound, whatever be the kind of lock, that might involve novelty. Maybe it's new to the world. It would involve a technical advancement which nobody has a foresight about, which is not obvious to a person skilled in the art. Nevertheless, he might have a problem here, because this is something which this invention cannot be worked or made and used in an industry. You cannot be allowed to do it. Government will not do it, allow it, because this is something which cannot be made and sold in the industry and may not be introduced to the society. So the requirement of capable of industrial application, that requirement within the inverted commas, would mean a positive utility. Positive utility could be understood in different ways. I've got some observations here. There must be a product, but this need not be an article or substance, but must be something in which a new and useful effect, be creation or alteration, may be observed. A certain observation in some of the applications. And there should be operability. There should be operational utility. There should be beneficial utility. There should be practical utility. These words are definitely not very clear-cut words, very defined words. These are vague words and vague phrases. I do admit it. But the concept is understood in that way only. There should be operation. There are very many cases. Diamond versus Chakravarti could be one of the cases in which these considerations have come in. Diamond versus Chakravarti is famous and notorious for very many different matters, but utility was also one of the considerations there. I can give some of the other examples, like a clock with 30 hours, a clock that is arranged in 30 hours. So instead of after 24th hour, you have 25th hour, 26th hour, 27th hour, 28th hour. Instead of 60 minutes, you have 1 hour, 100 minutes. Then it might be something new. It might be something non-obvious to the person skilled in the art. But still, it will not be given a patent because it will not have any practical utility. It may not have a beneficial utility. It may not be. It could be operational, but it cannot be operationalized in a positive sense. So put it in simple words, there should be a positive utility to have a patent. Now, there are these are the positive requirements of patentable invention. There are 3. It could be 4, or there should be a best known method made available to the persons. That is another requirement. Full disclosure, which we'll discuss when it comes to specification. Then only there could be an effective discussion on that. So as per the definition which we went through, there are 3 requirements. That is novelty, inventive step, and industrial application. These are the 3 requirements. So these are the positive requirements. You need to comply with these. There are certain negative requirements which the court will look into, or the patent office will look for, and that should not be present in your invention. Negative requirements, I would say. Inventions which are not patented. Let me give certain examples. There are very many subclasses for this. Let's look at a few subclasses. An invention which is frivolous. An invention which is frivolous or which claims anything obviously contrary to well-established natural laws. There is an invention. That invention is frivolous invention. Frivolous is a negative word. If the invention ultimately is a frivolous invention and is contrary to the well-established natural laws, then that cannot be patented. Let me give an example. A timepiece. This is something which was brought to the patent office, Bombay Regional Patent Office, in 1972 or in 1970s. The example which you have on the screen. A timepiece, a clock, having 3 hands for indicating hour, minutes, and seconds. Nothing great in that. That is something which is already existing. Was divided into 10 parts for us. Instead of 12 hours or 24 hours, if it is railway, you usually have a 12-hour clock and 12-hour timepiece and 12-hour watch. Here it is 10 hours. And each hour is divided into 100 minutes, not 60 minutes, please note. And each minute into 100 seconds. Just consider this. And just consider scheduling something, scheduling your whatever it is, scheduling something, scheduling your office hours or anything timetable, anything as per this. It's going to be chaotic, and it will create a lot of confusion. And you have that the invention was held to be frivolous, and Indian Patent Application number 101 of Bombay of 1972. Yeah, and this is the one. You Google it, you get it. This is the timepiece or clock I was speaking about. See, this is instead of 12, you have 10 hours. Instead of 60 minutes, you have 100 minutes. And instead of 60 seconds, you have 100 seconds. This was held to be frivolous. So even if you are complying with all the requirements, all the positive requirements like novelty, inventive step, and utility. When it comes to utility, there ought to be certain problems. Even if you are complying with all the positive requirements, if it is possible to show that your invention would fall into any of these categories, it's a frivolous invention, though there is inventive step, then you don't have a patent. That's what I'm saying. I think it's clear. Now you have clause B. This is a very, section 3 is speaking about the invention which are not patentable. It has got so many subsections. We may not spend so much of time into each of the clauses. We will just flip through these clauses. Section 3B. Section 3B. An invention, the primary or intended use or commercial exploitation of which could be contrary to public order and morality. There is an invention, and the primary or intended use. Your interpretation has a major role to play. I do understand. It's not very indicative. It's not without confusion, but still it gives some sense. 3B says, an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health, or to the environment. It could be it could be an invention of a machine, which I talked about earlier, which would allow you to break open the lock without any sound in 30 seconds. So it's against public order and morality. It could be, or it could be against plant life, health, or environment. So terminated technology could be. Terminated technology is something which is against animal or plant life. Or many of the biotechnology related inventions could be trapped into this or fall into this. So because of this, it may disqualify as invention. So I've just put a picture which is contextual. This is something which will go along. A device, apparatus, machine, or method for committing theft or burglary could be an example for this. Another example could be a machine or method for counterfeit of currency notes, which will definitely fall into this, even if it is complying with the novelty and inventive step requirements. And method of cloning, of course, you have arguments on both sides, but cloning also could be argued in this way. It's against the already existing natural laws, and it's prejudicial to human, animal, or plant life, health, or even to the environment. This is very widely worded and vaguely worded as well, but definitely it could be brought in here. Now, for moving to the next one is clause 3C, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. A mere discovery is not patentable. You are patenting, you are claiming a patent for something, a bacterium which is already existing. You have just isolated it. But please note, if the isolation of that itself involves a lot of technological requirement, technological challenges, and if you're overcoming all that and isolating a bacterium, then you might get a protection. But otherwise, you're just discovering something which is already existing. A living or non-living organism will not entitle you for a patent. And a scientific principle or formulation of an abstract theory, E is equal to mc square. Energy is equal to mass into acceleration. You know that. That is an abstract theory unless you translate that theory into some reality. Take, for example, atom bomb. Obviously, atom bomb will not be patentable because it's against all those. It's commonsensical. It comes under, it will disqualify as an invention which has got positive utility, and it will definitely come under section 3C also. Section 3 also. What I'm talking about here is, it's about the abstract theory, E is equal to mc square, or every force has an equal and opposite reaction. These are some of the abstract theories, theory of gravitation. Unless you come out with a product transforming this abstract theory into reality, you don't have a patent. So an abstract theory, a mere scientific principle or formulation, which Isaac Newton and Edison or Albert Einstein or anyone has come out with, will not qualify them, will not make them eligible or entitled for what you call an invention under Section 3C. Discovery of any living thing or non-living substance occurring in nature, a new new element added to the the table of elements, and which is already existing nature. Or as I already said, an isolation of a bacterium, a living thing and non-living thing. I was just giving examples for that. These will not make the person entitled for patent. Now, the next clause we may have to go to is Section 3D, which we'll do in the next class because we may have to spend some time on it. And I've got some cases to be introduced, which you might already know. So we'll stop at 3C. And if you have any clarifications to make, any contributions to make, any dissent to make, you have the time for that now. Otherwise, we'll break.
Yes, sir. I would like to differ on one aspect.
Okay.
Sir, it is regarding the utility. You mentioned that utility should always be positive. But I don't think that is required as per the definition. But at the same time, when we look into Section 3, only positive utility things are being granted patent. So I think it is a wrong interpretation to say that Section 2AC, which defines capable of industrial application, means that it should be positive.
May I have a response to this? My
Yes,
thoughts.
sure. I need your response, sir.
Okay. Yeah, if you go by the words, if you go by literal interpretation, and because if you are sitting as a judge and if you're prioritizing the rules, because for judges there is no rule which says that which of these principles, literal rule or golden rule, or which rule should be used as the first rule. And they have got so much of flexibility in that. But I believe, and some of the judges also say that the first rule of interpretation for a judge should be the rule of literal interpretation. And if you are going by literal interpretation, what you said is right, and I agree with you. I agree. I'm in agreement with that. But the courts have not gone with literal interpretation. I would say that court have gone with golden rule of interpretation, because if the result, if you're going by literal interpretation, and if it takes you to an absurdity, something which cannot be allowed, as the very policy of law, then you may have to go for a golden rule of interpretation. I think, and I believe rightly so, the courts have gone for golden rule of interpretation for that particular matter when they interpreted utility requirement. Because the very purpose for which patent law exists is to incentivize inventions which are useful to the society. Only if there is a technological advancement which is useful to the society, patent law will be serving its purpose. So considering this wider policy in mind, wider patent policy in mind, the interpretation that could be given cannot be an interpretation employing literal rule. So if you're considering this interpretation, we may have to improve the rule of interpretation, and we may have to employ at least golden rule of interpretation, or we may have to say that the purposive interpretation or beneficial interpretation, whatever you call it as. Or even if you are making use of mischief rule, what was the position had the Patent Act not been there? So, and what's the purpose the Patent Act is trying to serve? The Patent Act is trying to serve the purpose of something useful to the society. So, keep this wider policy in mind and employing the rules of interpretation, the rules of interpretation given by the court is a right one. So, I look at it from this particular point. So, in that, I'm with the courts, though the words are different. So that's how I exercise my Article 91A.
Oh, okay, sir. Sir,
Okay,
but
okay.
when
Thank
I
you.
went through the
Thank you.
cases related to utility, I never found the word positive utility. The word I found was practical utility.
Yeah,
So
yeah, that's
again,
right.
practicality can be both positive and negative.
That is right. I used the word positive. I used it, and you used it with after some meticulous thought. Because if you read it, see, take the example of knife. If you go, you can go on doing this also. Take the use of knife. Knife, you can kill a person with a knife. You can cut lady's finger, not lady's finger in the literal sense. That vegetable, not to cut the finger of a lady. You can cut chicken with that. You can cut tomato with that.
Yes.
So this is how you are going to interpret it. That also matters. See, E is equal to mc square. You can think no. You can think about E is equal to mc square, keeping atom bomb in mind. You can think about E is equal to mc square, the scientific formula, keeping nuclear reactor in mind.
Yes.
So you can interpret it. You can so that will depend on the ability of the advocate and the attorney also, and obviously on the judge as well. We may have to go to so much of judicial process. But yeah, you have a point. It's not a very clear cut area. It's a gray area. There is a lot of flexibility available, and maybe because of this flexibility that the lawyers do make their living. Yeah.
Definitely, sir.
So see, but if you go through all the cases, at least there should be positive utility also for that particular equipment or that product. Unless it is at least it is interpreted to be so, they are not going to allow it.
Yes, they won't allow
That's
it,
the
but
position.
not under that definition, but under Section 3. That's what my understanding is. For example, you gave
Yeah,
the
maybe they are,
example of
maybe
a device capable of breaking a lock. I am of the opinion that that device is having utility, but it won't be given patent because of Section 3B.
yeah, it could be like that also. Yeah, practical utility. How do you look at that practical utility? Yeah, definitely. You have a point. You definitely have a point. Section 3 also. Otherwise, Section 3 is not without any use because almost everything under Section 3 would come under that utility clause itself. Can be
Yes.
brought in under utility clause itself. Yeah. Mm, yes. Yes. Yeah. I agree. I agree. I agree. But still, I would think that uh, the I think for the reasons I've already stated, because the very purpose of patent law is to have incentivize something which is useful to the society. Uh, Even without this definition, uh, I would have given such an that's the point of view I'm just keeping. Maybe courts will definitely quote Section 3 also while giving this interpretation.
Okay, sir. Thank you.
Thank you. Thank you. Thank you. Thank you.
Mm,
Definitely. Yeah. Yeah. Miss Roshan, you have a point?
no, sir. I think anyone have any query, they can rise.
Yeah. That I thought you were about to raise. It's okay. It's okay. I think the debate or the conversation I had with Mr. Karun uh, has helped the other participants also, and even it has made me also to think better. Thank you, Mr. Karun.
Thank you for participants to make such a discussion and also to Sir for answering in a very effective and explanatory mode. I think there is no
Thank you.
further queries. Thank you, sir, for your valuable time.
We'll call it a day. Thank you. Thank you everyone, and a special thanks to Mr. Karun.
Sir, thank you, sir. And I would like to request the organizers to please share the link of the next session. I got this from a group. I don't know whether the next session will be given to me. So if there is any where I can access the every session of this discussion, I would be happy to get that link.
I'm privileged. Okay, thank you.
Thank you, sir.
I'll be privileged with your presence.
Me too, sir.
Okay. Okay, thank you. Bye. With your permission. Safisa, with your permission, I will leave.
Yeah. Thank you very much, sir. Karun, can you please share your mobile number?
Yes, sure.
Yeah. Thank you very much.
And thank you, Ms. Roshan, too. Thank you.
Thank you, sir.
I have added my mobile number in the chat box. I hope it's visible. Okay, thank you.